Okay, I know it's kind of brutal. We're going to lead off this morning with the new legislation. I am trying very hard not to repeat anything that's already been told to you, although there might be some overlap, so I apologize in advance for that. This is the first year that I've been tasked with doing the new legislation for all of the conferences, and so it is a daunting task. I read through all of it several times and trying to get as much information as I can and get that information out to you. There probably are some things. I tried to find anything that affects your office, but also anything that might affect you as a county employee. I hope that the information is useful and I don't lose you in the process. Senate Enrolled Act 67 has really already been implemented, and that you received that special distribution at the end of April. It had to go out before the 1st of May. And you have until June 1st to distribute to the taxing districts in your county, and I know a lot of you have already done that. It does provide for a special distribution of the county's LOIT balances that were in the trust account with the state as of December 31st, 2014. We introduced 2 new funds for counties as a result of this distribution, and I will be discussing those a little bit more when I do the chart of accounts presentation later today. I did want to clarify the funds. The 7315 is a remittance or clearing fund. That fund holds the entire distribution that you receive from the state until that distribution is allocated and distributed by the county to the other taxing units. Then a portion of the distribution that is allocated to the county, and at least 75% of that allocated amount, would be deposited into the 1129 fund to account for the county's use of those funds. So the 75%, at least 75%, and you can choose, your county can choose more than 75, but at least 75% must be used on 4 specific uses. And I've put those in the slides here, so I won't read them all to you, but they're listed from the statute here down under subpart A, what those can be used for. So there is no deadline to spend this money, so the amount that you do not spend in this year is going to carry forward. However, the limitations that are on these 2 slides stay on that balance until it is all spent. So the whole 75% has to be spent on this, so you do need to continue to track it. The statute does allow, and there's been some confusion on this, the statute does allow the funds to be deposited to the rainy day fund, and we will not take exception if you do that. However, even if you place it in the rainy day fund, the restrictions on the use of the funds remains, and you will have to ensure proper tracking of your disbursements from that rainy day fund in accordance with the statute and those uses that are listed on this slide. And then any balance of that 75% that remains in the rainy day fund would continue to have those restrictions placed on it, so as you carry forward in the future, you need to follow up. Yes? Yes, if the county chooses to use 100%, you can, but at least 75% and up. Okay. The remaining 25% may be used by the county for any county purpose, including roads. The money can be posted to your general fund, your rainy day fund, or an appropriately established home rule fund if you want to restrict the use on that. You do need an appropriation to spend this distribution. It does have to be appropriated no matter what fund is in. Okay, Mike already discussed the details for the multiple county PITA-BOAs. There's just a few things I wanted to point out. When the ordinance is adopted to establish the multiple county PITA-BOA, the ordinance should specify the manner and amount of reimbursement that the county assessor should receive from each participating county for work done for the board. The cost and the payment of the expenses and per diem compensation shall be apportioned among the participating counties, and that should also be specified in the ordinance how each county is going to contribute. Okay. The budget for the multiple county PITA-BOA should be added to the commissioner's budget for whichever county is actually controlling the, in charge of that section. The next slide is on the Senate Enrolled Act 148, and that's effective July 1st, 2016, and this applies to the Public Employees Retirement Fund. And I'm going to start out by saying I am not an expert on PERF and its how this all works, but I wanted to make sure that you were aware there were changes, because if you don't know that there are changes, you wouldn't know to ask questions about those changes. So just to give you a heads up on it, you can visit the NPERS website at www.npers.in.gov. So if you do have questions, that's one place you can go, as well as call them. So the traditional plan is the defined benefit plan, and that allows a defined monthly pension benefit once you have met the requirements of age and years of service. Then there's a secondary annuity savings account, which is a defined contribution account. This pays an annuity based on the contribution that you make or that your employer makes to the account. A new employee may make an election to become a member of the fund. The new statute states that once an employee has been allowed that election and then leaves employment and later returns to employment, they don't get a second chance at the election. They are sticking with the first one that they made. This bill also includes a new section under Indiana Code 5-10.3-7-4.3 for an employee that is a member of the defined benefit plan and the defined contribution plan can make additional contributions to claim years of service record in the defined benefit plan. The contributions must be in an amount calculated by the actuary for PERF. If the employee terminates employment before becoming eligible for a monthly pension amount, they may withdraw the personal contributions that they made under this section. The new statute also allows for periodic payments or use of funds in your annuity savings account for that contributive amount that we discussed in the last slide. Okay. It also amends Indiana Code 5-10.3-12-32 to allow a political subdivision, such as a county, to adopt an ordinance allowing an individual who meets the stated criteria to begin or resume membership in a plan for a period of reemployment. The criteria to include that person as a retired member of the fund is the person must be a retired member of the fund and are prohibited from making contributions during a period of reemployment that begins more than 30 days after rehiring, and they are rehired to a full-time position that would otherwise be covered by the fund after the date of the ordinance or resolution. Okay, the next slide is on Senate Enrolled Act 183. This is also effective July 1st, 2016. It's a new statute under Indiana Code 35-43-4-9. This doesn't really directly affect your office, but I thought you might get questions about it, so I would just mention it. It adds a new section for real property in foreclosure. Anyone who damages, permanently removes an object from, or defaces the property commits a misdemeanor or felony depending on the dollar amount of the damage. This only applies to mortgages and land contracts and not to mechanics liens, tax liens, or a lien placed by a homeowners association unless that property is also subject to a mortgage, land contract, or similar security interest. One behind. Senate Enrolled Act 232 is also effective July 1st, 2016. It adds a new chapter, which is under Indiana Code 36-7-8 on land banks. Distressed real property includes real property in a neglected or unmarketable condition. Eligible unit means a county, consolidated city, or a second-class city to which Indiana Code 36-7-9, which is on unsafe building law, applies. For a county, it allows the county commissioners to adopt an ordinance establishing a nonprofit corporation as an independent instrumentality to exercise governmental functions whose primary purpose is to manage and improve the marketability of distressed real property located in the county. The ordinance should establish the name of the nonprofit and the number of board members. The territory of the county land bank is all of the territory of the county except for any second-class city that has established its own land bank. The Land Bank Board has the authority to approve any purchase, transfer, or lease of real property held by the land bank, and the approval must take place in an open meeting of the board. That number of board members is between 7 and 9. The land bank, the new statute states that the land bank should endeavor to acquire a diverse portfolio of properties so that properties can be disposed of in diverse real estate markets in the county to generate revenue to sustain the land bank. The priorities for the land bank are outlined in this statute, and I've listed them on this slide. And so these are the purposes they're supposed to be going for. Within 6 months after the county has established the land bank, the county will furnish the land bank with a list of real property that is within the county for which a tax sale certificate has been issued or a tax deed that has not been committed to a redevelopment project or for another purpose. When the list is furnished, the county shall offer to assign the tax sale certificate or convey the real property described on the list to the land bank at no charge to the land bank, and the land bank may accept or reject the real property. There are conditions in the statute for the purchase, transfer, or lease of the real property. Basically, the term include that for a dwelling, the person must reside in the real property as a permanent place of residence for a specified period up to 3 years, bring the property up to minimum code standards within 12 months, carry adequate fire and liability insurance on the property, and if the purpose of the conveyance is to develop the property, cause development within 5 years, and comply with any other additional terms, conditions, or requirements that the land bank imposes. If the person fails to fulfill the agreement, the sale, transfer, or lease of that property is void. Under the new statute, disposal of real or personal property that's outlined in Indiana Code 36-1-11 does not apply for land banks when they're disposing of selling, leasing, or transferring their property. The code also sets out the people ineligible to purchase, receive, or lease property offered by the land bank and includes anyone who owes delinquent taxes and assessments, penalties, interest, or costs directly attributable to a prior tax sale. A foreign business, which is one incorporated in another state, may not receive property from a land bank unless they are certified by the Secretary of State and the foreign business is in good standing as determined by the Secretary of State. Land bank employees are not county employees. An exemption for a political subdivision owned property ends, so the land bank would have the exemption. That exemption ends on the final day of the first uninterrupted 48-month period that the property is leased or offered to lease all or part of the parcel of real property to one or more tenants. The land bank is subject to open door law and public records law. The State Board of Accounts shall audit the land bank. Okay, the next slide is on Senate Enrolled Act 238. Currently, the state will match dollar for dollar to a maximum of $10,000 the amount of money provided to a soil and water conservation district from its county. Effective July 1st, 2016, new legislation states that the district may receive that grant even if the county provides no assistance and the district receives their funding from another source. There's a new section added that if the district covers more than one county or less than one county, that maximum $10,000 is increased or decreased in proportion to the size of the district. Okay, Senate Enrolled Act 271, this bill is also effective July 1st, 2016, and establishes a state commission called the Indiana Commission to Combat Drug Abuse. And the former commission, what was it called? The Commission for a Drug-Free Indiana is now abolished, and in its place we have the Commission to Combat Drug Abuse. There is an 18-member board. The board includes the executive director of the Indiana Criminal Justice Institute, and the Criminal Justice Institute provides the staff support for the commission. The executive director of the Criminal Justice Institute will now be the one approving the comprehensive drug-free plans and funding requests submitted by your local coordinating councils. And again, formally that was the Commission for a Drug-Free Indiana that approved those funding requests and the plans. If the Indiana Criminal Justice Institute does not approve the comprehensive plan, the fiscal body may not appropriate any funds requested by the local coordinating council, other local entity, and that's the same as it was. It's just a new entity that's approving the plans. Okay, we're moving on to Senate Enrolled Act 300, effective July 1st of 2016. It also amends Indiana Code 34-55 on execution of judgments, and it removes the requirement for an appraisal when property is sold by the sheriff. When a lien is enforced and the court shall order the sale, there is no longer a need for appraisals on the property prior to the sale. The next slide is on Senate Enrolled Act 306. It's effective March 21st, 2016, so it's already effective. It amends Indiana Code 5-1.5-8-5. The statute currently allows the bond bank to notify the treasurer of the state to withhold any money from the qualified entity for failure to pay interest and principal due on securities purchased by the bond bank. The new legislation adds a new subsection that for all agreements entered into with the bond bank after March 1st, 2016, the bond bank can notify the fiscal officer of a county for any qualified entity that resides partially or wholly within the county, and the county fiscal officer shall reduce the amount of any revenues or other money that is held, possessed, maintained, controlled, or otherwise in the custody of the county or a department, agency, or instrumentality of the county, and B, would otherwise be available for distribution to the qualified entity under any other law. They are withholding an amount equal to the amount of the qualified to pay the amount that the qualified entity owes to the land bank, and then once you withhold it, you are responsible then to remit that money to the land bank. You also are required to notify the qualified entity that the amounts are being withheld and the reason you're withholding them. It also goes on to state that the amount withheld should come first from the local income tax distributions that would otherwise be distributed to the qualified entity, and then from any other revenues or other money that is in the custody of the county and would otherwise be distributed to the qualified entity. Okay. This act also added an amendment to 5-13-9-2 to extend the maturity limit of investments in municipal securities from 5 years to 10 years, which affects treasurers more than you, but I just wanted you to be aware of that. Senate Enrolled Act 308, effective July 1st, 2016, also, it adds a new section to Indiana Code 6-3.6-6-2.5. If the adopting body in a county is the local income tax council, and the adopting body did not allocate revenue under this chapter from an expenditure rate for at least 0.1% to pay for a PSAP in the county for a year, the county fiscal body may adopt an ordinance to impose a tax rate for the PSAP in the county. The tax rate must be in increments of 0.01% and may not exceed 0.1%. So if you don't have it established by your local income tax county, your council can then determine that you need that tax rate and establish it. The revenue generated by the tax rate imposed under this section must be distributed directly to the county before the remainder of the expenditure rate revenue is distributed. The revenue must be deposited to a separate, dedicated fund and used only for paying for the PSAP in that county. And also included in this bill is an amendment to Indiana Code 36-2-13-16, and it expands the use of the Prisoner Reimbursement Fund, which is Fund 1130 on the chart of accounts, to now include, if the balance in the fund is sufficient for the purposes set forth in subsection D, which is the operation, construction, repair, enlarging, and equipment of a county jail or a juvenile detention center, then the fund may now be used by the county for the costs of care, maintenance, and housing of prisoners, including the housing of prisoners in facilities of another county. So that is a new increase in that use of that fund. So if you need it, that's a good to know that that's out there. I think it was available for one county only, and now everybody has that. Okay, Senate Enrolled Act 309 is also effective July 1st, 2016. I'm not sure if this has much of an impact on your office at all. Mike spoke about this yesterday, so I don't want to redo everything he did on exemptions. But this is one of the exemptions that is being terminated. It's under Indiana Code 6-1.1-1-10-16 on exemptions from property taxes for land that was acquired for the purpose of erecting, renovating, or improving a single-family home to be given away or sold to nonprofit organization or a low-income family to use as a family residence. So I assume it's like Habitat for Humanity. The exemption itself expires after January 2nd, 2017, so there's only another year of it. Formerly, the exemption had additional requirements for reporting substantial progress, and that has been repealed. But if the property is granted for an exemption in the past, the owner fails to transfer the property within 8 years after the assessment date or transfers the property to a person who is not low income, or the individual does not use the transferred property as a residence for at least 1 year, that person that received the exemption must notify the county recorder and the county auditor in which the property is located not later than 60 days after the event described. Again, I don't know if that's ever going to happen, but that's what's supposed to happen. The county auditor is then to immediately inform the county assessor. It doesn't say what the county recorder is supposed to do with that information. The additional taxes owed and interest at 10% become a lien on the property. Okay, and again, there's another part in this bill which probably affects the treasurers more than you, but just so you're aware, it amends Indiana Code 6-9-29-3 that if an ordinance has been adopted requiring the payment of your innkeeper's tax to the county treasurer instead of the Department of State Revenue, the county treasurer has the same rights and powers with respect to collecting, which they always did, and refunding. Now, they've added and refunding the county innkeeper's tax as the Department of Revenue has. Okay, Senate Enrolled Act 310 was effective March 24th, 2016, and it amends Indiana Code 6-1.1-24.5-2 on serial tax delinquencies. So there were some changes made to the language on that. The phrase on the tax list has now been changed to eligible for tax sale. It changes the wording that the properties were acquired in a previous tax sale, but no longer requires that they be acquired by the respective owner of the property eligible for the tax sale, just that the property itself was in a previous tax sale. The legal description and parcel or property number must be included in the petition to the court. It also adds that the requirement that the property taxes and special assessments that accrue after the property is certified as eligible for tax sale must be paid before the appearance in court. If all of it is not paid, the county auditor is to issue a deed for those tracts or items of real property without right of redemption to the county. The date to appear in court for the owner of record may not be earlier than 30 days or later than 60 days after the date of the court's order. If the court determines that serial tax delinquencies exist, the court will send a copy of the order to the county auditor, who will remove the properties from the tax sale list and this has been added, remove the taxes and special assessments for which the tract or item of real property became eligible for tax sale, and all subsequent taxes, special assessment, interest, penalties, and costs of sale from the tax duplicate in the same manner that taxes are removed by certificate of error. Senate Enrolled Act 327 is also effective July 1st, 2016. I'm really not sure how this is going to work, so I can't give you a whole lot on it, but there is a new law under Indiana Code 5-14-3.8-3.5 that provides additional information that must be uploaded on Gateway, which is, well, you know what Gateway is. Contracts in excess of 10% of the county's property tax levy, or $50,000, whichever is less, must now be uploaded on Gateway. The next slide is on Senate Enrolled Act 355, and I want to be very clear on this because I think I gave the recorders a heart attack when I went over this for them. This is effective 3/24/16. It amends Indiana Code 6-1.1-24-1.5, and it deals with the notice of tax sale. So there were changes made for tax sale for properties that were not sold when initially offered. Now the county may omit the descriptions of the property in subsequent notices of sales if the information is available on the internet site. Subsequent notices of sales must include a statement that description of those properties are available on the internet website of the county government, and that the information may be obtained in an alternative form from the county auditor upon request. The county is then also required to actually place the descriptions of the property on the government's website. That goes without saying, but I'm going to say it. It also adds under Indiana Code 6-1.1-24-3.4 on the alternative form of the property descriptions, which may be electronic format, on a digital storage medium, or in printed form. The county is responsible to make the information available in the format requested. These requirements also apply to certificates of sale that are not sold at the initial offering. Also effective July 1st, 2016 is an amendment to Indiana Code 6-1.1-24-7. It now states that the owner of record of the real property at the time the real property was certified by sale under this chapter and before the issuance of a tax sale deed may file a claim for tax sale surplus. If the person who claims the money in the tax sale surplus fund is a person who has a contract or agreement described under subsection 7.5 of this chapter, or a person who acts as an executor, attorney in fact, or legal guardian of the owner of the record at the time of the real property was certified by sale under this chapter, the auditor may issue a warrant to the person only as directed by the court having jurisdiction over the tax sale. The court will only direct the issuance of a warrant on petition of the claimant within 3 years after the date of the sale on the parcel in the tax sale, and in the case of a petitioner who has a contract or agreement, then requirements of subsection 7.5 of this chapter must be satisfied. The section 7.5 did not change, but they did amend it to add the Attorney General and the Attorney General's Homeowner Protection Unit shall enforce this section. The court in which the action is brought may issue an injunction, order restitution to the owner aggrieved by a violation of the section, order a person that violates this section to reimburse the state for reasonable costs of the investigation and prosecution, and impose a civil penalty in amount determined by the court. There are also new requirements when a tract or item of real property is conveyed during the redemption period on the requirements to redeem the property. The person who received the property and wishes to redeem it must also pay the amount in the tax sale surplus fund in addition to any other requirements for redemption. It also allows the Department of Local Government Finance to cancel any property taxes, fees, special assessments, and penalties assessed against real property owned by a political subdivision, regardless of whether the political subdivision owned the property on the assessment date for which the property taxes, delinquencies, fees, special assessments, or penalties were imposed. This cancellation does not affect the liability of any person that is personally liable for the property taxes before the date of ownership was transferred. If the property taxes are canceled in accordance with this statute, the lien on the real property shall be released and canceled to the extent the lien covered any of the property taxes, delinquencies, fees, special assessments, or penalties that were assessed against the real property before or after the political subdivision became the owner of the real property. I'm ahead of myself. The bill also amends Indiana Code 32-21-2 on the recording process to add a new section, which is 32-21-214, that states a county recorder may not record a document of conveyance to which the one we just read, 32-21-8-7, applies unless the document of conveyance has been endorsed by the auditor of the proper county under Indiana Code 36-2-11-14. Under Indiana Code 32-21-8 on tax sale surplus disclosure is amended to add a subdivision 3 that the tax sale surplus fund disclosure form must have proof from the county treasurer that the person acquiring the property has paid to the county treasurer the amount required under Indiana Code 6-1.1-25 for redemption of the property. A new section is added on Section 7 that states that before the auditor can make the endorsement on a document of conveyance for the transfer of property from a delinquent taxpayer to another person after the property is sold at tax sale, the person acquiring the property must redeem the property by paying the total amount required and provide to the county auditor proof from the county treasurer that all required payments have been made. If the conveyance is not properly recorded before the expiration of the redemption period for that property, the conveyance becomes inoperable and void. The next slide is on Senate Enrolled Act 372. This went into effect March 21st, 2016. Again, I don't know that it affects your office, but it's information you might get questions on. It amends Indiana Code 24-4.4-2-201 regarding the requirements for a creditor or mortgage service to provide specific information to the debtor. This bill adds clarification that the disclosure requirements in this section are not intended to provide the owner of the real estate subject to foreclosure any defense against the deficiency judgment because of the failure to properly disclose the required information. Okay. The next slide starts on Senate Enrolled Act 366. It's effective July 1st, 2016. And amends Indiana Code 13-21-3-1. After June 30th, 2017, so next summer, a county may, not shall, a county may establish a joint solid waste district or designate itself as a county solid waste management district, but it is no longer required that those districts be established. Again, this is next summer. After June 30th, 2017, the county may dissolve the county solid waste district through an adoption by the county executive in favor of dissolution, adoption by the county fiscal body in favor of dissolution, and the action of the legislative body to adopt a plan concerning the dissolution in accordance with Indiana Code 13-21-15 and 36-1-8-17.7, which we'll be going over. If the county does not take action to dissolve the solid waste district or withdraw from a joint solid waste district, the district continues in existence. So Indiana Code 12-21-15 is on the dissolution of districts. The dissolution of the district, and this is a solid waste management district, is effective on the date specified in the ordinance. Upon dissolution, any legal obligations of the district that were incurred before the dissolution of the district, including bond obligations, loan obligations, other contractual liabilities, and civil liabilities, are transferred to the county and become legal obligations of the county. Any assets of the district that are needed to satisfy the legal obligations shall be used by the district to satisfy the legal obligations, or transferred to the county, used by the county to satisfy any legal obligations. Any assets that are not needed to satisfy legal obligations shall be transferred to the county and shall be used by the county to provide the services previously provided by the district. If the county withdraws from a joint solid waste district, the county is responsible for its share of legal obligations and assets and shall be apportioned to the county and used then to meet their share of the legal obligations. The county may continue any property tax levies, but those property tax revenues may only be used for the purposes previously established by the district. If fees were being collected by the solid waste district, the county may continue to collect the fees, but they may only be used to provide the services previously provided by the district. Okay. So this is the new section in Indiana Code 36-1-8-17.7, and this is on the dissolution of political subdivisions in general. So if you are dissolving a political subdivision established by another political subdivision for which, except as we just discussed in 1321-15, there is no process or procedure expressly specified law regarding the dissolution of a subdivision, then you follow this statute. The legislative body that established the political subdivision must make a preliminary resolution stating the intent to dissolve the political subdivision. For solid waste districts, the ordinance of the county executive in favor of dissolution satisfies that requirement. The legislative body must hold a separate public meeting regarding the proposed dissolution at least 90 days after adopting the preliminary resolution, or at least 180 days if the subdivision has existed for at least 10 years. At least 10 days before the public meeting, a plan must be made available to the public that outlines the effective date of the dissolution, a description of the assets and obligations of the political subdivision that is being dissolved and how those will be distributed, a description of the services currently provided by that political subdivision and how those services will be provided after the dissolution. The public must be allowed to comment. The next slide is on Senate Enrolled Act 371, and again, this affects your treasurers, but it amends Indiana Code 6-4.1. So an inheritance tax return after March 21st, 2016 will be processed by the Indiana Department of Revenue instead of the probate court, county assessor, and county treasurer as it is now. If an order has not been issued by March 31st, 2016 for a decedent who died before January 1st, 2013, the Indiana Department of Revenue will determine the fair value of the property interest and the amount of inheritance tax due. The Department of Revenue shall retain 2% of the taxes collected and will distribute 8% to the county, which is the current breakdown. Senate Enrolled Act 375, this was effective March 23rd, 2016. It amends Indiana Code 4-13.6-4 and adds a new section 2.5 that states a contractor must be qualified under this chapter before doing any public work projects as defined by Indiana Code 4-13.6-1-13 or Indiana Code 36-1-12-2, excluding the construction, alteration, or repair of a highway, street, or alley. A supplier, as defined by Indiana Code 4-13.6-1-20, the supplier is not required to be qualified, and the requirement to be qualified as a contractor applies to any contract awarded after December 31st, 2016, so it moves it out to the end of the year. Under Section 4.5 of this chapter, the Indiana Department of Administration Certification Board will certify the contractors and make that list of qualified contractors available on their website. This also amends Indiana Code 8-23-10.05, which states that a contractor must be qualified under this chapter before doing any work on a public works project that is the construction, improvement, alteration, repair, or maintenance of a road, highway, street, or alley. The requirement that the contractor be qualified is effective for any contract awarded after December 31st, 2016. And in this case, the Indiana Department of Transportation, or INDOT, will make available a list of contractors that hold a valid certification of qualification issued on their website. For both of these changes, for these public work contracts changes, there are exceptions for local public works projects. When a local unit awards a public project and the total contract is less than $300,000, and the local unit complies with Indiana Code 36-112, the current requirements for awarding that contract, the contractor does not have to be certified as qualified by the Department of Administration or INDOT. Senate Enrolled Act 380 is also effective July 1st, 2016. It amends Indiana Code 36.7.14 and Indiana Code 36.7.14.5 for redevelopment authorities and redevelopment commissions. If the redevelopment commission and a military base reuse authority adopts policies governing participation in electronic meetings for the redevelopment commission, redevelopment authority, and military base reuse authority, then votes may be taken at electronic meetings. There are requirements for the electronic meetings that must be followed, and those are outlined in the statute. Examples are all of the participating members and all members of the public who are physically present at the meeting must be able to communicate simultaneously with each other. In addition, at least 1/3 of the members must be present physically, and all votes must be taken by a roll call. Each member of these boards must physically attend one meeting annually. House Enrolled Act 1001 is effective July 1st, 2016, and amends Indiana Code 6-3.5-4, which is on county motor vehicle excise surtax, and Indiana Code 6-3.5-6 on county wheel tax. The bill expands the use of both the county motor vehicle excise surtax and the county wheel tax to include the county's, cities, or towns' contribution to obtain a grant from the local road and bridge matching grant fund, which is new under Indiana Code 8-23-30. The bill also allows the counties to increase the rate of the excise surtax and wheel tax if the county has an asset management plan approved by the Indiana Department of Transportation, or INDOT. And I don't have this on the slide because I just got this right before I came here. If your county needs assistance in developing the asset management plan, assistance is available from LTAP. LTAP stands for Local Technical Assistance Program. It's through Purdue. And if you need it, I have the website, or you can always Google LTAP, Indiana's LTAP, and it'll bring you to that. I went to their website, and there are quite a few resources listed under there. So if your highway department is probably doing this, but if you need to know, there is assistance available in getting that asset management plan established. Under the new statutes and the definition of the asset management plan, that does include plans for drainage systems and right-of-way that affect transportation assets. without the approved transportation asset management plan, the excise surtax, which is what it has always been, may be at a rate between 2% and 10%. However, if you get an approved transportation asset management plan, your rate may be increased to between 2% and 20%. Or the county may establish a flat rate between $7.50 and $25 under the old system, under the old statute, but with an approved transportation asset management plan. Got to be an acronym for that. The flat rate is between $7.50 and $50. For the wheel tax, without the approved transportation asset management plan, the annual wheel tax may not be less than 5 or greater than 40. However, after you get your plan approved, the annual wheel tax may not be less than 5 or greater than 80. Indiana Code 6-3.5-10 is added as a new chapter. It will allow eligible municipalities to impose an annual excise surtax. And it also, under Indiana Code 6-3.5-11, allows an eligible municipality to impose an annual wheel tax. This is separate from your county tax, and any revenues from this will be sent directly to the municipalities by BMV. So you won't be handling it, but I just wanted you to know they can also approve an excise surtax or wheel tax. Okay. Also effective March 23rd, 16 is the new chapter, Indiana Code 8-23-30, which establishes the local road and bridge matching grant fund at the state. An eligible project is defined as a project that is undertaken by a local unit, repairs or increases the capacity of local roads and bridges, and is part of the local unit's transportation asset management plan. A local unit is defined as a county or municipality. INDOT administers the state fund, and the funding sources include the appropriations from the General Assembly, interest deposited in the fund, and any money deposited or transferred from any other source. So the county or municipality may apply for the grant if the unit uses the Transportation Asset Management Plan approved by INDOT and commits to a local match by using one or more of the following: revenue attributed to an increase after June 30th, 2016 in the local unit's motor vehicle excise surtax or wheel tax under Indiana Code 6-3.5, money received by the local unit as a special distribution of local income taxes under Indiana Code 6-3.6-9-17, which was the special distribution you just received at the end of April, or money in the local unit's rainy day fund under Indiana Code 36-1-8-5.1. Okay. There's been some confusion on this, and it all has not been worked out, but they are working on it. There's a committee working on a technical correction amendment for 2017 legislation. And the intent is that the session the technical correction will broaden the local match sources to include any local funds which may be used for roads or bridges. In consideration of that change, and a memo was sent out, I think, Tuesday afternoon. In consideration of that proposed change, State Board of Accounts will not take audit exception to the present commitment of any money the local unit is authorized to use for local bridge and road project on these local match grants. So MVH, local road and street, major moves. If you commit to that, even though that's not technically in the legislation, we will not take exception to that for 2016. The application that you're going to send into INDOT for the grant will ask how much you're committing, and we're going to talk about setting up the grant fund, but yes, you're going to have to move it over to a grant fund to allocate it for the project.
So the 1229 fund that's already been set up, can you utilize that?
Yes, you can, because that's one of the ones in the legislation itself. We're just not, the legislation says only that the money in that 75% that's in that 1229 fund, money that's in your rainy day fund, or an increase in your wheel surtax wheel tax or excise surtax are the only three sources that currently are in the legislation, but they're going to do a technical correction to broaden that. And that's what we're saying. We are not going to take audit exception if you commit funds other than those three, if they come from funds that are specifically to be used for roads or bridges.
Okay, one other question. With those funds then that we've set aside, when you're matching, are you able to utilize those funds starting the process for the highway, or do those funds have to sit there until your grant is approved? And I'm not exactly sure how.
Well, the only thing I see is if the grant is not approved, you can continue with the project. You're just going to be missing half of what it's going to cost you. But, you know, yeah, I mean, if you want to get started and you've got money in that fund to start the project,
Okay.
the risk is if you haven't gotten approval from NDOT that you're going to be one of the grantees, you may not get your matching.
No, I understand that.
Okay.
Thank you.
This is kind of backtracking a little bit to the special distribution, and you telling us that we will have to account for that money if we put 25% in rainy day. What do you recommend? What is the best accounting way to account for that money in rainy day?
If you put 25% in rainy day, you don't have to track that. That's just rainy day funds.
I thought you said it was still committed, that it was still to be
You can choose
used.
to use 100%, but only 75% of that special distribution has to be used on road
Okay.
and street projects. That's what has to be tracked. If you
Correct.
put 25% in your rainy day, it's just like any other rainy day.
Okay. I
And it-
misunderstood. Thank you.
Yeah. Okay, there also has been some confusion because under the increase in the motor vehicle excise surtax and wheel tax, it says that any increase after June 30th, 2016. So depending on how you read that, it could be interpreted that you need to wait till after June 30th, 2016 to do your ordinance to establish or increase your wheel tax or excise surtax. We are not going to take audit exception if you have or pass an ordinance prior to July 1st that goes into effect for January 2017 to using that for the match. So it's ambiguous. You can decide whether you want to wait till after July 1st or you want to go before that. Your county will decide, but we will not take audit exception if you do go before that July 1st date for that. Yes. I don't think, I think they were talking yesterday, I picked up that they're within a couple of weeks of having the application ready. Most units are now getting that asset management. If you don't already have your transportation asset management plan, that's your first step because you have to have that before you apply. And so you want to get that in order, and then probably by July 1st, the application will be ready. No, I'm going to go over that right now. You're ahead of me. She asked about timing on the application, and the application should be available after July 1st. And that's what I said, probably your first step is getting that, which your highway department is probably already working on, getting that transportation asset management plan established, because that's got to be in place before you can apply for the grant. And then our other question was we're going to go over right now, which is the application itself. So your application must specify the amount that you are pledging as a local match. So you have to determine how much, what project you're doing and how much locally you can contribute to that. In an evaluation of the application, preference will be given to projects that are anticipated by NDOT to have the greatest regional economic significance for the region in which the local unit is located. If NDOT approves the grant to the local unit, the amount of the grant will equal the amount that the local unit commits to the proposed project. So you put up 50%, they're going to put up 50%. NDOT will allocate at least 50% of the grants made in the state's fiscal year to local units located in counties with populations of 50,000 or less. And then NDOT, which should be in place hopefully by July 1st, will be adopting guidelines to implement the grant program, including guidelines that establish a maximum amount that any one county may receive in a grant. House Enrolled Act 1017 also went into effect July 1st, 2016. It amends Indiana Code 5-3-1. Okay, there's a new statute defining a locality newspaper. This is one that meets all of the following requirements. Don't memorize these because I'll have a disclaimer later, but it is regularly issued at least one time per week, contains in each issue news of general or community interest, community notices, or editorial commentary by different authors, has more than one-half of its issued published in at least 12 months with not more than 75% advertising, has published for at least 3 years, has the capability to add subscribers to its distribution list, is the publication of general circulation within the political subdivision, circulated by mail or free of charge, has circulation verified by an annual independent audit, contains ads from numerous unrelated advertisers, is not owned by a shopping center or merchants association, and has continuity as to title and general nature of the content. It does not constitute a book, and it has a known office location in the county in which it is published. For political subdivisions, except counties, notices may be published in a locality newspaper when there is only one newspaper published within the political subdivision. But you guys don't get to use that, but everyone else does. So, sorry. House Enrolled Act 1019 is effective July 1st, 2016, and amends Indiana Code 5-14-3-2, defining law enforcement activity and law enforcement recordings, and those are recordings of law enforcement activity. So a law enforcement recording means an audio, a visual, or an audio-visual recording of a law enforcement activity captured by a camera or the device that is provided to the law enforcement officer. So these are dash cams, body cams, however they're doing that. This is a public record. The new statute specifies how it may be requested as a public records release and when it may be inspected or copied. I'm not going into, it's all in the statute if you want to read it. I'm not going into all of that because I strongly believe you are not going to be deciding which ones get released. That's going to be up to your sheriff's department and your attorney. But you might get the request. The request does have to be in writing. They cannot verbally request this. You may charge a fee for a law enforcement recording duplicate that does not exceed the agency's direct cost of supplying the information and does not exceed $150. Indiana Code 5-14-3-8G, any fee collected under the subsection G for the copy shall be placed in a dedicated fund and may be used without appropriation. This is one of those times where you pay attention, without appropriation, to purchase cameras or other equipment for use in connection with the agency's law enforcement recording program, for training concerning law enforcement recording, and to defray the expense of storing, producing, and copying law enforcement recordings. Money in this fund does not revert to the general fund at the end of the fiscal year. So you got a new fund if you charge the fee. House Enrolled Act 1025 is effective July 1st, 16, amends 36-7-4 on rezoning. There is a new alternative procedure to apply to rezoning proposals. So now if the Plan Commission makes a favorable recommendation, that rezoning proposal becomes effective in 30 days unless someone is aggrieved or the legislative body of the county notifies the Plan Commission that they intend to review it. If the Plan Commission makes an unfavorable recommendation or no recommendation, the proposal is defeated after 30 days unless an aggrieved person or the legislative body notifies the commission that the legislative body will be reviewing the proposal. So if the Plan Commission is notified in either case, the legislative body will consider and make the final determination. But if there is no aggrieved person or the legislative body is fine with it, then it's going to pass after the Plan Commission approves it or defeat it after they either have no recommendation or unfavorable recommendation. Okay, House Enrolled Act 1032, we're back to PERF. This is effective July 16, and again, the disclaimer, I am not an expert on PERF, I just want you to be aware of this. The guaranteed program as an investment option for the annuity savings account ends January 1st, 2017. There is a new investment fund called the Stable Value Fund, which will be established after December 31st, 2016. The annuity savings account currently consists of contributions to the annuity savings account, interest earned, or the guaranteed, that guaranteed fund, or the gain and loss of a market value in an alternative investment program. So after the change, the annuity savings account at the state level will consist of all contributions to the annuity savings account, the gain or loss in the balance of the stable fund, and the gain or loss in the market value of an alternative investment program. So after December 31st, 2016, you may not make a contribution to the guaranteed program. For all members who currently designate their contributions to that guaranteed program and have not changed their designation prior to January 1st, 2017, MPERS board will designate one or more alternative investment programs, and that designation remains in effect until the member makes another allowable designation. For all accounts currently in the guaranteed program, the board will exchange the amount in the guaranteed program to an equivalent market value allocation in that stable value fund. And if you have more questions about it, especially if you have your money in the guaranteed program, you'll want to contact MPERS and get some guidance on that. So after December 31st, 2016, you may allocate contributions and money invested in any alternative investment program back to that stable value fund if you want to start using that. Okay, and I don't know if this is going to affect all of you, but I just wanted you to be aware of it. This is House Enrolled Act 1053, effective March 21st, 2016. It amends the Home Rule Ordinance, Indiana Code 36-1-3-8. So a local unit may not pass a Home Rule Ordinance regulating the manufacture, distribution, sale, provision, or use of or disposition of disposal or of auxiliary containers, so like plastic shopping bags. A unit may not impose or adopt or enforce an ordinance to impose any prohibition, restriction, fee, or tax with respect to auxiliary containers. However, this does not restrict or limit your curbside or other recycling programs. And if you wish, you may restrict the distribution, sale, provision, use, or disposition of auxiliary containers at any event organized or sponsored by the county that takes place on county property. I know you've already heard a lot about this at House Enrolled Act 1081, which talks about the change in the LOIT. Again, for our perspective, the important things is LOIT ceases to exist and local income tax, I don't know if we're going to call it lit or not, but local income tax starts, and this is going to affect our chart of accounts because we have CAGIT, COIT, CEDIT designations, and some of that is going to change, but I'm going to talk about that later this afternoon in the chart of accounts. Okay, House Enrolled Act 1087. Okay, this was a 449-page bill, and I did read it. I didn't print it, but I read it. And it does a complete overhaul, or fairly complete overhaul, for BMV and their organization. Modifies several chapters of Title IX, which is under motor vehicles. And I am not going to give you any summary of all 449 pages. There are a few things I wanted to point out. There was a small change to Indiana Code 6-1.1-7-10, adding that a permit to move or transfer title to a mobile home when taxes, and it now adds special assessments, interest, penalties, judgments, and costs that are due and payable on the mobile home have been paid. So that's to transfer, move or transfer the title. Just for your information, it does amend to allow BMV to charge a fee for the application of an affidavit of a transfer to real estate. The fee is going to be $20 before January 1st, 2017, and $15 after that date. It's not your fee, but they will be charging it for transferring from mobile home to real estate. Effective March 24th, 2016, it adds section 1.7 to 9-22 on abandoned mobile homes located in mobile home communities, mobile home parks. The new law allows for procedures for the landowner who finds that a manufactured home has been left on land owned or controlled by that landowner without permission for at least 30 days, and there are procedures for that landowner to be able to sell or salvage the manufactured home if it is not removed by the homeowner. They will be notifying, there's a whole bunch of information on notifying by the landowner, notifying the homeowner, but the landowner of that mobile home community must also notify the county treasurer in which the mobile home is located by certified mail, return receipt requested. The notice to the homeowner must state a description of the home and a demand to move the home within 10 days of the notice. If the mobile home is not moved, it may be sold at auction. If the mobile manufactured home is purchased at auction, the amount received goes first to the reasonable attorney fees of the landowner, the payment of liens or secured interest in the home, and lastly, to the county treasurer for payment of delinquent property taxes and any special assessments, interest, penalties, judgments, and costs attributable to the delinquent property taxes. If no bids are received on the home, the landowner may donate the mobile home. And I am going to read the statute. I am not going to interpret this because I think I'm not sure. But the statute states, and I quote, "After the purchaser, landowner, or donee presents the Bureau with the affidavit of sale or disposal, completes an application for title with any other information the Bureau requires, pays an applicable fee, and provides evidence of the payment of any delinquent property taxes and any associated interest and penalties as provided under section 6F3, which talks about, we just talked about, it goes first to the attorney fees, then to liens, and then to the taxes and penalties owed to the county. The Bureau shall issue to the purchaser, landowner, or donee a certificate of title to that manufactured home." Okay, House Enrolled Act 1090, the only thing I wanted to point out to this is that membership on a local emergency planning committee is not a lucrative position now. It must have been before, but it is not now. House Enrolled Act 1102 allows DOC to make additional grants to county jails to provide evidence-based mental health and addiction forensic treatment service. I think some of the counties are already receiving this. It also includes a provision that the community correction plan must include a collaboration with any other local criminal justice agencies that receives funding from DOC. And they are encouraged in formatting the plan to include the courts, prosecuting attorneys, public defenders, and sheriffs when addressing the needs of the local criminal justice population. The only change in this, and I don't know how much it affects you, but if someone is transferring, they're classifying their land as native forest, they now go to the assessor, not to the auditor for that. And Mike talked about this yesterday, about the allowing the taxing unit to transfer property tax receipts from a fund that is not a debt service fund to a property tax assessment appeals fund. And there was a fund established, 1228, for you to collect on the chart of accounts for you to collect those funds if you decide to do that. And Mike already talked about that. Okay, House Enrolled 1290 adds a new chapter under Indiana Code 11-1211. It reestablishes the county misdemeanor fund. That had been repealed last year, and then we had told you you won't be getting any further distributions. Then we found out there were still appropriations, so you're getting further distributions, and now it's back. So hopefully that just goes along the way it did, but you will be getting distributions for the county misdemeanor fund from the state again. It also talks about amending IC Code 36.7.14.8 for redevelopment commissions, and talks about them, the funds must now be accounted separately by the unit. I don't see a change in that. You've always had to keep your RDC funds separate from your other funds, so you should continue to keep them separate. The RDC funds must be available to the Redevelopment Commission at all times unless waiver procedures are allowed. The funds may not be reduced below zero, but no fund should be reduced below zero unless it's in a reimbursable grant fund. And the redevelopment funds may not be maintained or used in a manner that is intended to avoid the waiver procedures. The waiver procedures allow you to do an interfund loan between redevelopment commission funds and other funds in the county. So you have to formally do that. You can't go and in-run around that. But if you do an interfund loan, it adds to that process that you must get a waiver from the redevelopment commission before you can transfer that money. So the fiscal body and the redevelopment commission must adopt similar resolutions that state the amount of the funds that are going to be allowed to be borrowed and the term, how long you're going to have them, and expiration date for the waiver itself. Under House Enrolled Act 1298, I'm not going to a lot of this because Chan is going to talk about this, but under the remonstrance petition for annexation, it's adding a section for if the municipality has valid waivers, they now must provide that information to the county auditor, and those must be included in your certification for property owners that have signed a valid waiver. So we will be updating the form on that. The last one we're going to talk about is House Enrolled Act 1372, and it did some changes for the bonds. I'm going to go over it kind of quickly, although it affects you guys. There is a clarification, so it defines a contractor, and it excludes financial institutions. Your banks are not contractors, and they do not have to be bonded. Employees and contractors, they did change for the recording of those because it's adding employees and contractors, so that the bond is now to be recorded in the office where the employee or contractor works, not residence, which was the previous requirement. It also added that threshold of $5,000. So if you have an employee that does not receive or have access to more than $5,000 in a year, they do not have to be bonded. Blanket bonds are allowed, and that's now included in the statute as long as the blanket bond covers the name or position endorsed to cover faithful performance of all officers, employees and contractors, and includes aggregate coverage sufficient to provide coverage amounts specified in the statute. A crime policy may be used in lieu of a bond as long as it also covers faithful performance and includes the aggregate coverage sufficient. The Commissioner of Insurance was to prescribe forms, and they have done so. There are 3 forms that were developed. These forms are still available for use, but they are no longer required. With statute now allows a continuous bond to be used for the term of office if the bond is renewed on an annual basis for the official's term of office, provides coverage in the amount required for the official for each policy year. And so that's a new change to that. You didn't have the continuous bond before. A claim under a continuous bond must be brought not later than 6 years after the occurrence in which the claim is sought. So that kind of puts us under the gun, because if we're not auditing for a couple years, which hopefully for you guys that won't be a problem, but for some of the smaller units it could be, it cuts into that time. The maximum aggregate liability for a continuous bond for the entire term the bond is in effect is the penal sum, which represents the maximum amount the security company will pay on a claim for a particular year for the current term of the bond, and the penal sum for the 5 immediately preceding years. And finally, it talks about exit conferences. Last year, we had changed legislation that your final audit report may not be issued more than 45 days after your initial exit conference. But under the new statute, we've got a little more leeway. If the state examiner does not call for an additional exit, the legislative body of the unit waives their additional exit conference. Or if the state examiner determines that a report should be issued as soon as possible, then the report may be issued in less than the 45 days. And it also added a little bit that allows that $5,000 exemption for school employees, which doesn't affect you directly, but just so that you know that school employees have that same.